Yes, subscribe, press the subscribe button, press the notification button, and stay tuned and get all updates about this channel. Subscribe to the channel and like the videos. Yes, I salute you all. Thanks for listening and thanks for watching. So basically today we are under the law of torts, and basically simply we are looking at tort law 1 or the law of torts 1 basically. And the emphasis that we are going to look at is the trespass to persons. We are going to look at the elements in each of the concepts or the social liability under trespass to person basically. We are going to look or to highlight on the elements basically, on the elements of each tort. And basically in the thing that I can advise you that while you are answering such number, first go back to the history. Look at the history where the trespass persons came from, where these particular torts came from basically as a result. So realize that once you show where the history, or once you show how these torts came in existence or where they came from, then you have now the onus to start discussing the social liability basically. So we shall start with assault and battery. I'll start with assault. Assault basically, this is an act done by a person that brings the immediate apprehension onto another person basically. The key element is that immediate apprehension basically. That is assault. That if at all someone, even if he wants to box you and the box doesn't reach, that immediate apprehension is like the fear that is instilled in the other person. That's what amounts to assault. The assault here now in tort is the kind of different from the assault in criminal basically. So basically let's differentiate the two. So under here we say that assault has like three elements basically. We look at the immediate apprehension. There must be immediate apprehension. There must be intention of the defendant and the act of the defendant basically. And also the act must be unlawful basically. We can also say that the act being unlawful. So those are the key elements that can highlight what assault means. For example, we have the case of Stephen versus Mayers, whereby they were in a local just meeting and the other party wanted to box the chair of the meeting, but however people came in and intervened before he could reach the box to the chair. So but however court held that his act amounted to assault. So basically not that in mind, his act amounted to assault. So that's the key point under the case of Stephen versus Mayers. And also what you have to know, even words can amount to assault. Words themselves alone can amount to assault. What do I mean, or what do I mean here is, it means that, for example, you have the case of Taberville versus Savage, where the other one lamented and said that if it wasn't the time of Aziz's time, I wouldn't take such language from you. He spoke these words while his hand was on the sword like this. But however, court held that such words did not amount to assault because they lacked the intention to cause harm, basically, or intention to bring immediate apprehension. Because like someone says that if your dad wasn't around, you would have seen me. It means that your dad is around, which means he won't do anything. So that's what was insinuated in the what? In that case of Taberville versus Savage, basically. You also have the case of R versus St. George. R versus St. George. It says, for it brought out that element of immediate apprehension, that if at all you point a gun on me like this, and the gun it is not loaded or doesn't have a bullet, and you press me, I'll get scared, because me, I don't know whether the gun is having bullets or it doesn't have. So you, the person that has pointed to me by the gun on the head, you can be liable under assault, have a cause of action against you. Reason being that your action has brought an immediate apprehension in me, regardless whether the gun was loaded or not. You get, so not that about. So basically that is the brief that I can talk about assault. For the, if you want defenses and remedies, look for another video that will explain that. So basically then we go to battery. We are all under trespass to persons. When you go to battery, for it, battery, unlike assault, this is a physical touch. Actually, it is a physical hostile touch on another body. Basically, it is a physical hostile touch inflicted by another part. You get, in this essence, the elements of battery, there must be a physical touch, the touch must be hostile, there must be the intention of the defendant, and the act must be done by the defendant. You get, so the difference between assault and battery is that assault, there's no need of physical touch, whereas battery, there must be physical touch, however slight it may be, but it can be hostile. You get, we have the case of Pringle versus Wilson. The case of Pringle versus Wilson, these were people these were kids actually, they were playing just as usual, they were playing. So the other one pushed the other and fell and sustained injury. So the court held that the touch amounted to an hostile touch. Hostile touch, it is looked at that the touch you have told me what is its repercussion, which damage has it caused. That's how they will determine that your touch is hostile. Then we have the case of Collins versus Wilcock about the two prostitutes. If you are well versed, Collins versus Wilcock about the two prostitutes, whereby this police officer saw two prostitutes. One was known, another one was known. So he went ahead and wanted to know where the other was coming from. So the other was walking away, tried just coming after her. So he touched on the back of the other prostitute, as stand like this, he scrawled his neck basically and left scratches. So the court held that the act of that officer amounted to battery. Reason being that why he was liable under battery, because first of all the actions were not lying, they are not lying in his duty basically. I beg you look for that case and you look at it basically. So basically that's what I can talk about. That's what I can talk about battery. Basically, that's what I can talk about battery. Then, the other one that we go to false imprisonment. False imprisonment, basically this is confinement. We all know that it is confinement basically. And confinement, basically we see that when you look at Article 23, it talks about personal liberty, what and what. So, in this essence, it talks about that someone must be given free. It must be given free. So false imprisonment, this is the restraint of a person's free movement. That's the point that I can use. And this essence, when I'm talking about false imprisonment, don't assume that I'm talking about arrest, I'm being taken to prison. No. Even if I'm seated here, the way I am, someone is seated next to me, and is pointing a gun on me saying that don't dare move, that can as well as mount to false imprisonment. Which means you can be confined wherever you are. It is not basically that you have to be taken in custody as a result. So basically not that in mind, or bear that in what? In mind as a result. We have like 4 elements under false imprisonment. And we have the case that there must be total or complete confinement, the intention of the parties, the restraint must be unlawful, and the act of the defendant, basically. Not that in mind. We have talked about total or complete confinement or restraint, intention of the defendant, the restraint being unlawful, and the act of the defendant. You read the case of Birds versus Jones. The case of Birds versus Jones, it brings out these elements, all these elements of what? False imprisonment. Whereby the act, once you are imprisoned, or once you are blocked in these regards, that however much when you read the case of Birds versus Jones, they did not succeed, reason being that there was a way through. And Birds versus Jones, for it emphasizes that the restraint must be complete. or there must be complete or total confinement. It means that there must not be a way of exit. Let me give an example. When, for example, when they block the road, when Museveni is passing, they block the road, the vehicles, what and what. Could that amount to false imprisonment? The answer is no. Reason being that you have a route of exit, which is where you are coming from. You can exit and go back. So that cannot amount to false imprisonment. So false imprisonment doesn't give you any room for exit. For example, if you are confined in the room, there must not be window for you to escape. Or even if you are confined in the room on the upper floor and the window is open, there is risks of you jumping through the window and you sustain injuries. So that is also total or complete what? Complete confinement as a result. The act being intentional. In this essence, what do I mean that the act being intentional? The party must have intended. Intention can either be an individual to confine you or to procure your confinement. You get? For example, you have the case of Hannett versus Bond and another. Under this case, this person had gone to consult, or the doctor, basically, the doctor in his office. So when he went, a lot was happened, and this person called the police, and he procured, or he told those people to confine, to arrest that person. So the court held that the defendant was in wrong. Reason being that for the intention, for them to prove intention, they don't need for you to be present or for you to do it yourself. No. Even if you yourself, you order someone to confine someone, it amounts to false imprisonment. Even if you call for me police and arrests me, you are the procurer, and that could amount to intention as a result, basically. So note that in mind. You get? For intention to be determined, you can either act it individually or act it through someone, or as when you are procuring as a result, basically. So note that in what? In mind also. Then we also have we also have the restraint being unlawful. What do I mean by the restraint being unlawful? The restraint being unlawful, it means that it is not in order, basically. You don't have any authority, you don't have any mandate, you don't have any audacity to do what you are doing. You get? We have the case of James Onyango versus Bukedeya, district administrator. You get? Where this the plaintiff was arrested for 10 days for refusing to involve in a self-help project. So his arrest was unlawful. Reason being that the defendant, who was the Bukedeya district administration, didn't have the authority, didn't have the mandate to detain such a person, basically. And also the act of the defendant is also vital. It is like participation under criminal. You get? So bear that in mind. And also, before we go any further, say that the act of the defendant, the plaintiff's knowledge of knowing that is being false imprisoned is irrelevant. Basically, not in that. The plaintiff's knowledge of him being that is detained is irrelevant. The example is like this. It is irrelevant for the plaintiff to know that he was detained. No? For example, let me give an example. If I'm taken into an office and I'm made to sit in the office to wait. So as I'm waiting, the person tells me wait here and goes out. Unfortunately, I'm locked inside, but I'm not aware that I'm being confined here. So when later I get knowledge that I was locked, I can sue. It doesn't need me for me to know that I'm being restrained from here. No, it is irrelevant. So basically, note that the intention on the side of the plaintiff, knowing that is being confined, is irrelevant. Basically, note that in mind. We have the case of Hearing versus Bolly. Hearing, Heering, Bolly is Boyle. Under that case. So in this essence, or in this S, is that the police held that where a person is being confined or is being falsely imprisoned by the plaintiff, his knowledge or his awareness of such act is irrelevant to the courts of law basically. But however, the only thing that he needs to prove are the other agreements, which is the intention of the what? Of the plaintiff, of the defendant, his intention basically. So basically not that in what? In mind. So basically when you go to malicious prosecution as our fourth what? Our fourth element in trespass to person, malicious prosecution has like 4 elements basically. And the elements, they are portrayed under the case of Olango versus Anthony Gino, among other cases. But I'll more so emphasize using the case of Olango versus Anthony Gino. And malicious prosecution, one of it is that the criminal proceedings must be instituted by the defendant. That is one of it. The criminal proceedings must be concluded in favor of the what? Of the plaintiff. The defendant must have acted maliciously. The defendant must have acted without probable cause. You get? Those are the ingredients and the act of the defendant at last. Those are the elements that we see under malicious what? Prosecution. That Olango versus Angel is criminal proceedings instituted by the defendant. Why do we say that they must be instituted? Reason being that malicious prosecution, this is where someone makes allegations on you to be arrested. But at the end of the day, you win the case. Reason being that the case has no substance. You get? For you just only to prove that the criminal proceedings, for example, rape, I was charged of rape by you. The charges of rape were turned in my favor. I won. And the charges that you brought them maliciously. And the charges you also brought them without probable and reasonable cause. You get? That is under malicious prosecution, basically. Then the last one that we are going to conclude on is nervous shock or psychiatric injury or injury without impact. Under this under nervous shock, as history came, it's for you to recover under what? Under nervous shock, you have to prove injury. But however, the law changed. You know, the law keeps on reforming and say that you can also recover under shock alone. Under nervous shock, basically, this is injury that is sustained, a mental distress, basically, that is sustained as a result. And we have like 4 categories in this essence, whereby the act must be harmful, must be on the mental. Basically, you have 2 theories under nervous shock. We have the impact theory and the shock theory. Those are the 2 theories. The impact theory, this is where the injury, you recover damages from shock directly flowing from physical injury. That is the impact theory. You recover damages from shock directly flowing from physical injury. Then shock theory, you only recover what? You only recover because of shock as a result. Basically, you only recover because of shock as a result. So we have the case of Wilkinson versus Downtown, whereby this lady was deceived by a person that his husband he had sustained, he went to the hospital. As a result, he started vomiting, he suffered nervous shock, and he recovered damages. However much the person was lying, but the court held no. They look at the element of foreseeability, that you foresaw that you lied to him that his husband was bad love, which means it was foreseeable that he was going to sustain what? Injuries and nervous shock. Then for shock theory, you have the case of Bonhill versus Young. Bonhill versus Young, this was a bypass on the motorcycle, and he witnessed a motorcycle that was hit. He witnessed an accident. There was heavy blood flow. As a result, he sustained injuries as a result. So when he sustained injuries, he sued for shock, because the shock, he was traumatized. And the person that they sue the person that caused the accident. However much we shall get more of nervous shock under Tort 2, under negligence. You get? So we have 2 victims under nervous shock. We have the primary victim and the secondary victim. For the primary victim, this was a victim that gets involved directly at the scene of crime. You get? It gets involved directly at the scene of crime. You get? For example, let me give an example that, for example, the case of Bonhill versus Young. The case of Bonhill versus Young. This person was at the scene of crime. For the primary victim, you are either the person that has been involved in the injury, in the accident, or you witnessed physically, you are the scene of crime. Bonhill versus Young. You also have the case of Page versus Smith, where he recovered because of the element of the physical injury, that the mental illness that he got as a result of the minor accident that he sustained. So that is for a primary victim. Then for a secondary victim, you recover because of relationship or the proximity or the relationship you have with the party. For example, let me give an example of the case of McLaughlin O'Brien. I don't know whether that's a pronunciation, but that's the case there. Under that case, this person witnessed his people being, his people were seriously injured as a result. So at the end of the day, he could recover because the relationship that this was his family, this was his husband, these were his children as a result, basically. So not that in mind. We also have the case of Al Clock versus Chief Constable of South Yorkshire Police. That case where people died in the stadium, we all witnessed that. Even at Freedom City, it once happened. However much tort law is not much effective in Uganda, basically. But in the case of Al Clock, this was the same things that happened. People witnessed on TV live when people were dying in the football pitch. So court held down that for you to recover as a secondary victim, you have to prove the closeness, you have to prove the proximity, you have to prove the relationship that you have with those parties for you to recover as a secondary victim and another shock. So these people failed. Reason being, they failed to prove the relationship they had with the people that we are watching on what? On TV. You get? Let me hope we are all on the same page. You get? Other than that, for the defenses and the remedies under trespass to persons, please look out for another video. It will explain all. But other than that, thank you for listening and thank you for watching. Stay blessed.